Hey, good afternoon to everyone. An introduction to law. I just got back from court, so I thought, what a better, not a better time than really to do a quick review of Chapter 8 dealing with ethical standards and ethical principles that apply to the legal profession. It's a very important chapter. The book does a nice job, so I don't think I'm going to be too long in this review because the book is very comprehensive and does, I think, a very nice inquiry into this area. Um, for lawyers, ethical rules are very, very important, not just simply because lawyers are supposed to do the right thing. It's to ensure lawyers do the right thing because the ethical rules are actually embodied in law because these rules can be enforced against us through the licensing agency. Every state has one. Massachusetts is called the Board of Bar Overseers. They determine our eligibility to be a practicing attorney in the state of Massachusetts, things like passing the bar exam and things like that. But also, you actually have to take another exam. It's just usually just before. Sometimes you can take it after, depending on timing. There's actually an ethical exam you have to take to make sure you understand the ethical rules and canons of behavior and expectations that we have to be knowledgeable about the ethical rules that are in play in the legal profession. Uh, Lawyers get a very bad rap. There's no question about it. Probably throughout history, I think Shakespeare had a work that referenced the first thing we must do to basically cleanse society or create a utopia is to kill all the lawyers. So it's been around for a long time, and the profession being imbued with a sense of dishonor and dislike. And I believe there's been polling done in recent years that suggests that the only profession with less credibility and integrity is that of a used car salesperson. Um, I think that's very unfortunate. And sometimes I wonder why it is. I don't know if it's because lawyers cost so much money, why there's so much disdain for it. I think part of it can be because we have an adversarial system of justice, meaning that we come within two conflicting parties come into court to litigate their conflicts. In doing so, they proposition two different scenarios that occurred factually and argue different legal applications should apply to a situation. And it's often, I think, perceived that lawyers are sneaky and always trying to basically do one-upmanship without regard to integrity or the truth. And the adversarial system of justice was designed or is designed to bring these clashing of ideas over factual allegations and legal standards to hopefully reveal the truth through that conflict. I'm not sure if that's why lawyers and law firms and the practice of law has such a negative reputation, but it does. There's no question about it. Well, let's do what we can here to prevent it from getting any worse. And that's because not only do some of you are going to go on and become lawyers, there's no question about it. Some will become legal assistants or paralegals. Um, some won't even work in the legal profession, but that doesn't obviate the need to really try to make an effort to comply with the ethical rules and standards that are out there. Attorneys that don't comply with these ethical rules or standards really face significant sanctions, including losing their licenses for either a period of time, suspension, or for disbarment, just removal from the practice altogether. And it is actually taken very seriously. People say, oh, you can't do anything about an unethical lawyer. You can, and many unethical lawyers do lose their licenses all the time. In fact, there's a newspaper most lawyers get, or many do in Massachusetts, called Lawyers Weekly. And in there are published all the attorneys that have been reprimanded, either privately, meaning they'll just say a certain number and not the attorney's name and what they had failed to do or did inappropriately and why they're being reprimanded. Then there's public reprimands where the attorneys are actually named, and therefore there's a certain degree of um, reputational stain, if you will, for having been publicly reprimanded. But then there's suspensions, and even within the reprimands can be requirements that you take further educational um, classes to improve where you're lacking in terms of your ethical understanding of the legal principles that you violated. But then there's suspension multiple years, and then of course permanent disbarment. And some of the ethical rules and standards obviously overlap with criminal law. If you're taking money from your client's account and spending it on your own needs and desires. And even if you intend to reimburse that client, if you get caught, that's a form of embezzlement. It's obviously a violation of the ethical rules too. Anytime you commit a crime in the relationship of you and your client, you're probably committing a crime as well. But they overlap. The ethical rules definitely clearly overlap. Well, sometimes paralegals and legal assistants, legal secretaries, staff, agents of the law firm, accountants, investigators, whatever it is you use to extend the ability of your law office to serve your clients well, they are also bound by the same ethical rules, but they're not necessarily subject to any kind of sanction from the government unless a law has actually been violated. But why it's important is the attorneys are ultimately responsible vicariously for any ethical violation their paralegals or legal assistants or staff has done. So it's very important everyone's on the same team in following the rules and principles. Most of the ethical rules are obvious. Some are a bit nuanced and surprises people the different things you can't do or ought to refrain from doing for fear that you will have somehow tainted or abridged the full faith and loyalty to your client's interests. It's a fiduciary duty you're in as an attorney representing a client, and that fiduciary duty is held to a very, very high standard, and you must always keep the client's best interests in mind, and anything that will interfere with that should prevent you from either taking the case or withdrawing from the case, or certainly making it known to your client that there's a potential problem that they should be aware of and be informed so they can make an informed decision about the continued representation of the firm. And I'm just going through the different aspects of the book. Now, paralegals and legal assistants in Massachusetts are not licensed. In those states that they are, they could lose their licenses or be suspended, just like attorneys. If you're in a state like Massachusetts that does not license their paralegals, the ripple effect, though, is the attorneys, if they don't redress unethical behavior by their paralegals and legal staff, they can be suspended and fired vicariously through not basically managing the law office appropriately. But I'm just going to go through the ones they talk about. Competency is the first one that jumps up right away. Lawyers are barred, even though you pass the bar exam. Technically, you can take on any case that comes before you, but you have an ethical duty to refrain from taking cases you don't have competence in. So, well, there's always a first case, right? And that's some of the advice you get if you go on to law school. You'll learn about, it's called hanging out your shingle, going at it your own. You want to open up your own law practice. Well, how is it you take a case when you don't have any experience in it? It has to be sort of that first attempt. And that's what they say. Will you take your first attempt on lesser significant cases that you can come up to speed with fairly rapidly to give your client due representation and due diligence and be able to competently represent him. So if I'm just out of law school, have no experience, no knowledge of it, and a very complex medical malpractice came into my office, I might be violating the rules for competency by taking on such a significant complex case without the skill and experience that are appropriate. There are things you can do to prevent that by surrounding yourself with other experts, getting what we call of counsel, more seasoned, experienced attorneys to help give you advice. And you can take further training in those areas, but it shouldn't be done while you're representing someone in a very complex, new, novel matter. Like I don't do anything in patent law. If somebody came in all I do pretty much now is criminal defense work, but if somebody came to my office and says, hey, I've got this great patent idea, I really quite honestly know the principles that underlie patent law, but I wouldn't know where to go and where to start and how to file the paperwork. I'd be incompetent, and I really should refrain from doing it. I should refer it to a more competent attorney or surround myself with attorneys that could help and guide me if I had the time and the wherewithal to invest in the process to ensure I do a competent job. It's kind of common sense in that area, I think. I think when it comes to competency, you'd be surprised. Some attorneys will take anything that walks through the door, and that's an injustice to the client. It really needs to be refrained from. It's kind of common sense. Confidentiality, that's the big one. That's the fun one that students like to talk about in a traditional live, brick and mortar classroom. We'd be in there, we talk about confidentiality. Anything a client tells me, well, almost anything. There's always some exceptions. I must keep secret. Not only must I keep secret, and it's the client's confidentiality. Although they call it attorney-client privilege, I'm barred from revealing it, but my client can waive that. I cannot waive it. So if my client tells me something that's, sometimes it's salacious and interesting and crazy and wild, but maybe doesn't have a ton to do with the case, I can't go out to lunch with my buddies who are not affiliated with the law firm and don't represent the client or have any, they're not going to be there to give advice or counsel. Of counsel, another attorney, just my buddies who have nothing to do with the practice of law. I meet them on a Friday night, we're going to go out and play softball or whatever we do. People probably still bowling. And I was like, hey, let me tell you about this crazy story my client was involved in. Well, if it's objectively, if the facts are known to the public in terms of the public realm, I could comment and talk about it. But if this is client information that was relayed to me by the client, I and my entire staff must refrain from speaking about it whatsoever without the client's consent. Now, believe it or not, if somebody comes up to me and say, hey, do you represent Joe Smith, the one that robbed the bank yesterday? I would actually have an affirmative duty to actually keep the fact I'm representing the defendant confidential until such time as I file my appearance in court, and now it's part of the public record. It's really a very, very strict rule. You have to keep communications between you and your client private unless the client has given you overt permission or whether it's implicit for you to do your job. So if I have a client and they want me to offer settlement on a divorce case to their spouse's attorney, obviously have implicit consent to call the other side and tell them what our stance is and what we're hoping for and our proposition for resolving the case. That's an implicit consent to communicate some information to certain individuals. But confidentiality is sanctimonious, and attorneys get in a lot of trouble for revealing private issues with clients all the time. Now, I'm a criminal defense attorney, so I've never had this actually happen to me where my client would come in the office and says, yes, I did that act. I did break into Walmart at night and I stole, a bunch of tools and equipment that was valued at thousands of dollars. I did it. But Corman, I want you to go fight it. I want you to beat it because they never can prove it's me. If that were to happen, I'm in a real ethical bind. And here's why. I can't reveal that my client has confessed to me that they did the act. And now they want me to fight the case. Can I fight the case ethically? The ethical rules say I can, provided I don't allow the client to testify to give an inconsistent set of facts that I know to be opposite of the truth because they've confessed to me. But could I still challenge the government's case against my client? What witnesses they have, what proof they have, shoot holes in their case, and perhaps get an acquittal for my client? I'd actually have to do that. I've always had fairly good luck when I have a client come in and they tell me, yeah, I did it. I've got this problem, these money problems, whatever. I thought I saw a chance. I was working at Walmart, so I knew how to get in. And I'll say, well, then we're going to do a disposition and I'm going to get you hopefully the best resolution I can possibly, even though you're culpable and you're responsible. And we'll see what kind of mitigating circumstances are in your case to give you a punishment that's fair and appropriate. I've always had good client control, but I had a I don't call him a partner, he's one of my closest friends. He's still a practicing attorney. He had a case where a client was charged with operating under the influence. And it was a very, very serious because it was third offense. OUI, it can be a felony technically. It's a pretty serious offense. And the client told my friend that he was guilty. Oh, I drank so much that night. I was obliterated and I drove. And then he turned around and did just that scenario I said. Says, but I want you to fight the case. So ethically, he could not report what was told to him by his client, but he couldn't allow his client to get up on the stand and testify, no, I only had one drink or I didn't drink at all, because that would be suborning or promoting a known falsehood. That's suborning perjury. That's also an ethical violation. So you're put in a special quandary. So in my friend's case, he challenged the government's case. He wouldn't allow his client, he wanted to withdraw, but the judge wouldn't let him because the client still wanted to keep the attorney. And guess what? So he's trying to withdraw. You can't tell the judge, the reason why I want to withdraw is my client told me he or she is in fact guilty of the crime. You can't report that even to the judge. So you see the ethical dilemma, and you have to say, well, due to inconsistencies with my ability to represent the client well with regard to our personalities and our vision or preparing for the trial, we've come into some conflicts in terms of our personality. He or she would be most effectually represented by a new attorney, so I'm going to withdraw. Some judges kind of read through the grapevine and say, okay, you're released from the case. Some judges won't. They won't let you off the hook. So you have to stay on the case. So what do? You challenge the government's case without aiding the lie. I think you're still aiding the lie because you're trying to suggest to a jury that there isn't sufficient facts to find your client guilty, yet you know the truth to be something different. It's a very serious ethical dilemma. So in my friend's case, I actually was in court that day, had the trial, and it was near the end, and I said, what happened? He said, the government had a very strong case against my client. He didn't testify. I expect the jury will be out soon, come back soon with a guilty verdict. The jury came back while I was there, and I always like watching juries when they come in and render the verdict. And the defendant was found not guilty. And my friend, who's I think probably the most ethical attorney I've ever met, was deeply shaken by that process, by that ethical dilemma that he was in, because he couldn't reveal the confidentiality about the client's confession and admission, but he felt he aided and advocated for a clearly guilty individual. And it really troubled him deeply. So anytime I've ever seen a defense attorney go over to a prosecutor after the jury was discharged and let go and apologize for winning the case, he's still troubled by it, because it's going to be 25 years ago that case happened, and I still tease him about it a little bit because it's bothered by it. I've never had that happen. Have I had clients that I thought the evidence revealed in preparing for the trial that there's overwhelming guilt on my client? But I tell my client that you're telling me you didn't do this, but there's all this evidence that suggests otherwise. I think you're probably going to get convicted. Now's the time to make an admission if you want to perhaps avoid a lengthier jail sentence or more serious ramifications, because that's often what happens if you try a case and deny your culpability when in fact you are culpable. But it's a very important confidentiality. You have to keep. Now, the major exception to that troubles people is, so-and-so admitted they robbed the bank to their attorney. The attorney should admit it. No. And the reason why that I actually agree with the need to keep confidential information secret is because your client wouldn't have the candor and it's just like meeting with your psychiatrist. I don't meet with a psychiatrist, but I have family and friends that meet with counselors and therapists. Imagine if that was going to be reported. It's the same kind of sanctimonious rule. Imagine, things that you talk to your social worker about, or you should say your social worker, your psychiatrist or your psychologist, your counselor, your spouse, your attorney. These are all special fiduciary relationships. And if you couldn't reveal information to these people without the expectation that it would be reported to other people, to the world, it would put a chilling effect on our ability to prepare appropriately and have candor. So I think the rule is appropriate, but it does bring up some very serious dilemmas. The one time you can reveal a client confidentiality beyond permission, client can give you permission, of course, it's their right, they can waive the confidentiality, is if your client's telling you they're going to go out and do a new criminal act where human health and safety and or significant property loss will occur. Like, yeah, I did this, and next week I'm going to go out and I'm going to burn down that guy's farm and kill his family in an arson attack. Now you have an affirmative duty to actually reveal that information. Ethics aren't that bizarre to ban you from doing that. That's obviously an affirmative duty to reveal that. Just like a psychologist, if someone's in there and they're having some emotional problems and they say they're going to go hurt themselves or somebody else, that person has an affirmative duty to report those things. Conflict of interest is a big one. Geez, I thought I'd be done in like 10 minutes because it's a short chapter, but I tend to go on and on and on. Conflict of interest comes up quite a bit in different kinds of law practice. You're representing somebody, but if you win for them, it might hurt your investment in that. Your client wants to sue a bank because it's maybe a huge, big loan process, and there's hundreds and hundreds and hundreds of thousands of dollars, if not millions of dollars at stake. And if you win for your client, it'll hurt that bank. Well, it turns out your spouse works there, or you have shared. That's a conflict of interest. You have to be leery of conflict of interest, both subtle and overt. And what do I mean by subtle? What if I had a child that was hurt in an OUI accident, and because of that, I was been very much in the forefront of advocating for very strict OUI laws operating on the influence. And I think it's really inappropriate to drink anything and drive, even though that's not the law. Could that taint my ability to represent a client in an OUI case when they're the defendant? They've been charged with operating on the influence, and say they got in an accident and they allegedly injured somebody. Would that be a conflict of interest for me as an advocate to punish people that are driving under the influence of intoxicating liquors on the one hand, and on the other hand, representing someone trying to basically get an acquittal for them to avoid punishment or sanction for something they've alleged to have done that I find very heinous? You see the difficulty in conflict of interest? Oftentimes it's over money, though, and interests like that. Or say that, I'm representing someone and I find out the victim of crime is a good friend of one of my kids. Do I have a conflict of interest? Sure I do. Maybe it turns out I know who the victim is, the alleged victim is. Does that create yes, it does. In fact, I just picked up a case last week where the defense attorney had to withdraw because the defendant was involved in an incident, and it's an assault and battery, and the victim is the former client of this attorney. So does that relate to yeah, because once you have a client relationship, it lasts for eternity. Even though the case is closed out, it's gone. The duty of confidentiality and loyalty and good faith to the client remains forever. And so you could always get permission from that previous client saying, hey, I see you're the victim on this case. I represented you a long time ago. Do you mind if I represent the perpetrator of the act against you? We could waive it. I'm uncomfortable with that, but you can do that. Just like in a divorce. This isn't in your book. At least I didn't notice it in your book. In a divorce, sometimes you get spouses come in and it's called a happy divorce. They're getting along so well because they can't wait to get rid of each other. And so they come in your office, they want to get a divorce, and they come to some agreement for, say that their kids are grown or whatever. So it's not a very contentious one over custody or anything like that. And they seem to be very mature, and they recognize how the property should be divided, and they're happy, and they want you to represent them. Well, if I talk to both of them in that meeting, I already have a conflict of interest, because even though right now there doesn't seem to be an adversarial quality between the parties, could the situation break down where all of a sudden that we're going to fight over the dog or something like that? Now, which side can I pick? I can't pick any side because of the conflict of interest that developed as a result of the confidentiality that both of the parties have given me in the past. That's why spouses should have separate representation, or only one of the spouse gets represented by me. I will not talk to both at the same time. And I've had that happen before. A couple comes and goes, oh, we heard you're a good guy, you're fair, you're reasonable, we got this agreement worked out, will you represent us? And I said, wait a minute, I might represent one of you, but I can't represent both. And before you both start talking to me and giving me your confidence, it'll taint the process. So if you want me on the case, I can only take one of you, and the other one, I highly advise getting another attorney. And they'll say, all right, you represent Mrs. Smith. We know you're a good guy, but guess what happens like a week later? Mr. Smith starts calling you up with some questions. And I have to say, what? I don't represent you. Remember, we had that conversation. I represent Mrs. Smith in this divorce. And I say, yeah, but I just want to know, it's fair, right, that this is happening or that's happening? I can't give legal advice to the opposition. So conflicts of interest are very significant. They come up a lot in family law, come up everywhere, criminal law, you name it. I've actually had it happen one time right at the eve of a trial. I was representing a fella, and his alleged victim was some person, a very common sounding name, if you will, for lack of a common surname and first name. And then we had a trial date scheduled, and they come to court, and I look in the witness, and I see, I ask my client, did you see the alleged victim show up for trial? Because yeah, she's sitting right over there. I look over and I said, I've represented that woman before, and I had. I just didn't pick up the connection between names. That's why we're supposed to keep, and I do keep it, but it didn't pop up. A conflict of interest, that was before the software was available. I used to do it in the old 3x5 card system, but now I have computer software that I put names in. So when any other new names come in, there's a cross-referencing software program that the names will pop up to see if there's any potential conflicts of interest from previous clients or defendants and plaintiffs in different cases. Very important rule, conflict of interest. Comes up a lot. If you get in trouble with conflict of interest, it can be disbarment for the attorney, even if it's the paralegal that has a conflict of interest. Boy, they put all the rules in there. Zealous representation, that's another big one. And I think that's why sometimes we get a bad representation. You have to fight for your clients. You don't have to be a jerk about it, but you do have to be aggressive, and you have to, and I mean, aggressive being loud or banging on the table. I don't think that style helps clients. But I mean, you have to really take every tact to win your client's best outcome. That isn't being tricky. It's not being unfair, but it is taking every opportunity you can to advocate for your client's best interests. And it's zealous. That's what the role is. Actually, the training we take as criminal defense attorneys to take public defender cases, it's actually called zealous advocacy in the district court and superior court. So you have to really do due diligence as well. It's related to zealous advocacy. Due diligence means you got to promote your client's interest. You can't just sit on it. And one of the reasons why I like to do criminal defense work is there's a limited timeline for, you have to make decisions. You're either going to do a plea, you're going to do some motions, or you're going to have a trial, or do something dispositive to resolve the case in a certain amount of time frame. So you have to kind of move. The court will be on you to make you move. It's kind of like there's a fire under your butt the whole time. So the motivation's there and it tends to get done. But sometimes divorces can languish and just keep on the back shelf. Neither side is really pushing to get court dates, to get pretrial conferences in and get a trial date for resolution. Same with personal injury or other types of cases. It's very easy for an attorney to let things just sort of slide and, as I always called it, collecting dust. A very, very dangerous habit to get into. And one thing is a good diarying system. This is not my regular diary, but I have one diary. This is one I keep for my stuff in the court all the time. But most attorneys keep something called a red book diary because it has all the attorneys' names in the back. Everything's electronic now, but the red book in the old days, a lot of attorneys still use it from my era, is you write down things like, okay, I got the case today. This is what I'm going to do on it. By this date, these little ticklers. So you're looking at the dates and going, oh, I got to go work on that case today. I got to follow up with some discovery rules, or I got to follow up with filing that motion. You need to do due diligence. So along with zealous advocacy is this sort of due diligence, moving the case forward and not neglecting your client. And just as a sidebar, I don't think sidebar, I'm talking in court, as a side note, the number one complaint against attorneys isn't stealing or lying or cheating. It's actually not getting back to your client and keeping them informed about what the status of the case is and what you're doing for them or what needs to be done, if anything. And I learned that very early on because I was always interested in, you see these polls come out. I'd read this thing called Lawyers Weekly. It's a newspaper a lot of lawyers read here in Massachusetts. And I always thought it was kind of amazing. That's the number one complaint people have against their attorneys. They don't get back to them. They don't keep them informed. They don't return phone calls. I made it a habit because I think it gets goodwill. It's not because I'm a great guy or anything like that. I just don't want that gnawing feeling in the back of my mind that she's a client called me 2 days ago and I didn't return her phone call. I really try to get back to my client as quickly as I can. And part of my slogan is to get back to my clients within 24 hours. Even if I don't have anything to say to them, clients want to know, are you there? Do you know I exist? I'm paying you some money, or the government's paying you some money to represent me. What's going on? And sometimes there is nothing going on. We're waiting to get that report from something, or the videotape from the surveillance information, whatever it is. Or if it's a personal injury case, we're waiting for your wounds to heal to find out if you have permanent scarring or if you're going to be able to return to work and function. But just call them. Tell them that. Paralegals and legal staff can help a great deal in facilitating that. Sometimes they do want to talk to the attorney. Paralegals often know more about the nitty-gritty, what's going on with a case. But the paralegals can call, and then they can come back and say, Jim, the client would really like to talk to you. All right, great. Let's get them on the phone right now. But sometimes they'll be happy to talk to the paralegal, give them an update. This is where we are right now. The one danger in that, which is related to the ethical rules, guess what they often ask? They ask questions. Well, what do I do next? What will likely happen there? The paralegal in answering that might be giving legal advice. That's a huge ethical violation. So sometimes I would, my paralegal that I used to work with all the time, her name was Deb. She was fantastic. We would talk ahead of time. Like, if this question comes up, tell them Jim Corman said this is what's likely to happen. So it's not them giving legal advice. It's me giving legal advice, and she's just reporting it on to the client. Sounds like we're trying to bend around an ethical rule, and perhaps we are on some level. But Deb, she knew all the procedures and protocols and steps that we were doing for our clients anyways. So we would have these conversations to say, these are the generic sort of parameters of what we're going to say. And sometimes it's just nice to say to your client, not nice, but it's appropriate to say to your client, we just don't have that answer right now. Attorney Corman will get back to you, or whatever, in the next day or two to give you the answer. If there is an answer, some questions don't have answers. So now I'm just looking at the end of chapter questions. Why are attorney-client communications privileged? So that we can have candor, openness, without fear of disclosure, because that's the only way to prepare appropriately. Sometimes clients have embarrassing things to tell you that don't go to the merit of them being good or bad, but they don't want to. Hey, don't worry. Anything you tell me is a secret. Like, I have a case coming up right now, and I don't want to. Well, I better not give any details on that one. I can do it this way. My client was believed to have done something wrong. Well, my client wasn't even there. I have an alibi witness. It was a family member that was in the event, driving the car and things of that nature in all likelihood. And so they should be able to tell me that kind of information without me going to report it to the police or something like that. That's a hypothetical. So that comes up from time to time. Ethical wall. I don't believe in ethical walls. I don't think they work really well. So you have a law firm, there's 7 or 8 attorneys, and a client comes in, boy, it's going to make us some good money. And it turns out there's a conflict with one of the attorney's spouses in the firm. We'll create what's called a Chinese wall. That they took out that term Chinese because it's probably considered somewhat derogatory using the term, but it's about the Chinese wall. It's not to be derogatory against the the race or ethnicity of being Asian or Chinese, but the Chinese is basically to build a big wall. That attorney cannot touch this case, have any knowledge about the case. They're going to completely stay out of it. That way we'll preserve our ethical standards by not having a conflict of interest. I'm a little uncomfortable about it myself, but it can be done. I'm just not too keen on it. Any taint, in my mind, of any kind of problem, it's best to just walk away from it. There's money to be made in other realms. Conflict of interest, we talked about that. Paralegals and employees all have the same ethical standards as the attorneys. They might not get sanctioned directly, but the attorney will, and it'll have a trickle-down effect. The firm will ultimately close down, have a place to work potentially. So who's bound to keep the attorney-client privilege communications? Everyone. And if there is a conflict of interest, you should withdraw. You need to seek court permission to do that. Competent representation. Yeah, it says right here, when can an attorney act as the only counsel in a case such as a dissolution of a marriage? I'm of the opinion never, unless the other side is representing themselves and they're not giving any legal advice or any counsel. It's a very dangerous issue. In fact, sometimes I'll get hired by somebody and the other spouse won't have the money. Sometimes you have these spouses that don't have equal bargaining power. So the spouse that comes into me happens to have the money. I don't know, whatever, they have access to money their spouse doesn't. And they'll say, well, I'm not so worried about my spouse. He's not going to have that much money. I'm the wealthier one in the family. He's going to represent himself. And I actually say to my client, you know what would be wise to make sure that this divorce is done fairly and, well, honestly. That's what ethics relate to, right? Is let's offer your future ex-spouse financial ability to go pick out the attorney of their own liking. We'll write a letter to them. We'll say, we'll give you the retainer. We don't pick the attorney. We don't hire the attorney. In that we highly recommend they have an attorney. They can say no, but what does it look to the court if later on they, say, my wife had this really great attorney and he really, befuddled me with all the legal rules and principles. I feel like I've been cheated. And then the judge will often, very early on, say, well, did you try to hire your own attorney? And they might say, well, I didn't have the money. And then we can produce the letter saying we were willing to pay the reasonable attorney's fees for the opposition to make sure we could come to either a settlement or the trial process be done fairly. Ethics is a big deal. Reputations get made very quickly. It's amazing how quickly. It's funny, when I was thinking about that today, I was in court and a bunch of friends, and some of us are moving from offices because of a building that's been bought by the city of Worcester, and they're moving out. They're all talking about, seeing if we can find new people to share office space with, and they're all talking. And guess what comes up on this? Yeah, this one would be a good person to be with. They're ethical. We talk like regular people to us. Yeah, that's a good gal. That's a good guy. What we're really saying is not that they're good people and we like being around them. We're also thinking about ethics. We don't want people to have the taint of being unfair or sandbagging the other side, not being frank and open and honest with not only the court but with opposition. You want to maintain that reputation because it lasts a long time. And so try to be appropriate and ethical whenever you can. A little bit long, but any questions, any concerns, don't ever be afraid to give me a buzz. Take care.